You will tell me that you are seeing the screen. Um, I hope that you are
Yes,
seeing
sir.
the screen. So, I told you that on Tuesday there will be questions from Study Guide 1, questions from Study Guide 2. So, it's very much important that when you get a question, you're able to see that this is the question about misrepresentation. This is the question about someone who has enriched himself. So most of the questions will come from Study Guide 1, from unjustified enrichment. So look, we can say that 70% of the questions may come from the Study Guide 1, and the others, there may be some few questions. They can come from Study Guide number 2. However, it doesn't mean that you must not prepare for Study Guide number 2, because Study Guide number 2 also will be. So let's start with the study guide number 2, or let's start with the study guide number 1. On the study guide number 1, we have covered everything. I said yesterday, I said to you that general enrichment, we have two questions. It's Miss Kathy, and then we have the general enrichment. I've sent you the document about the general enrichment, so that it's gonna be easier in the examination, so that there won't be a much problem. The general enrichment, as I've said, it has not developed in South Africa, due to the reasons that we have listed on that one that I sent to you. And then it's going to be much easier general enrichment. Now, when we talk about the compensation for work done, I said that there's a contract for work and there's a contract for service. And I said that the contract for work is the contract which you are hired to do a special um, job. Like for example, you want to build a house, you call a contractors to come and build your house. After that, you pay them, then they are done their job. That is a contract for work. So it's the contract that you are hired for a specific job, then when you are done, you are done. I said contract for services. Contract for services is when now you are like employee. You have to be given services, and then you will be given a monthly remuneration. That is a contract for services. Now, in the examination, the examination will come with a contract for service rather than the contract for work. So there will be contract for service rather than contract for work. Yes, now on the 2023, on this one, that's where I started with the general enrichment, which I've answered. And I said that here the question was saying, write a critical discussion on the existence of general enrichment in South Africa. Then I said that it's on study unit 14. I gave you about the Nonje case and what was the decision which denied the existence of such a general existence, that nonetheless contemporary development, including the influence of constitutional values such as Ubuntu, continue to challenge and shape this position, which now we can see. And there are many, like a condition deputy, condition obtainment, velam. There's a many that also they're embracing a general enrichment to the unjustified enrichment. I given the case that you can see now, the turning point one, which the case was the case of the non-J case, which I have given a. The Bota J held that no general enrichment action existed in South Africa law. The recognized enrichment actions were limited and specific. A's claim did not fall within any of them. The court reasoned that if such a claim were to succeed, it will have to be on the basis of general enrichment principle, which our law had not succeed. It will have to be on the basis of general enrichment principle, which our law had not yet adopted. Border JA did, however, leave the door open for future development, noting that while South African law had not yet reached the stage of recognizing a general enrichment, such as development might still take place. Thus, Nonje formally rejected a general enrichment action. Now, I also give other cases like a Miss Kathy, where the Supreme Court of Appeal appeared to decide enrichment matters without strict reference to the requirements of the specific action. We have a Nissan, we have, but in all, we have concluded that while South African law does not yet formally recognize a general enrichment action, judicial and academic developments indicate a gradual movement towards such recognition. The strict limitations imposed by NONJI are increasingly being questioned in the light of the constitutional order and the principle of Ubuntu, fairness, and good faith. As the courts continue to refine the law of enrichment in line with these values, it is likely that South African law will in future embrace the general enrichment action, one that ensures justice between parties and align private law with the transformative ideals of the constitution. But now it has not yet developed. So that is what you must write when you get a question about general enrichment. Remember, sometimes it can come with a 20 marks, sometimes it can come with 10 marks. So if it is 10, you will summarize to 10. If it is 20, you can write everything.
All right, sir.
Yes. Yes, remember, we're still here on the contract for services. And then the scenario that you'll get is like this one. The scenario says X is employee of company Y. X is paid a monthly salary of 30,000, which is payable at the end of the month. During July 2023, X receives a very lucrative offer from company Z. Provided he can start work immediately, X does not return his employment with Y. After 20 July 2023, Y now refuses to pay X anything for his employment during July 2023. Advise X whether he has any claim against Y, and if so, they discuss the nature of the claim as well as the amount that he can claim. Now, I said on this question that the guy is earning 30,000. He worked from the first day to the 20 July. Then it means that he didn't work for 10 days. And then we come to talk about the contract for work. We're given some cases there. I've written many things because I wanted you to have a nice summarize on this one. And in conclusion, I said that X has no claim against Y based on the contract of employment because he failed to complete the full contractual period. However, he does have a valid claim based on unjustified enrichment under the action for quantum merit. The nature of the claim is enrichment based and not contractual. The amount that X can claim is the lesser of his impoverishment and Y's enrichment, which in the case will generally be equivalent to the pro rata portion of his monthly salary. That is 20,000. Y's refusal to pay any amount at all will therefore be unjustified, as it will allow Y to be enriched at X expense.
Salary.
Yes.
Okay.
The amount that he has to work. So if if he earn 30,000, you know that he's gonna be working for 30 days. So in the 30 days, it's 30 divide. If it's 30 divide, sorry. So you have to divide how much he was getting per day. Then you will know. So you will say that 30,000 divided by 30.
In a case where they might try to maybe trick us, does it qualify? Because we said a month is, let's say the contract says that he has to work 30 days. That's a month. It's a month-to-month salary. Or maybe let's say they just said it's a month-to-month contract. He must work the whole month. And then maybe they work 29 days. Would we still then say it's unjustified enrichment?
Well, if we go to the contract, let me put you to the contract for a little bit. Let's go back to the contract. I hope you remember when we talk about the exceptional and plenty contractors, when we were doing the contract. When we check even the case of BK tooling, when we talk about the reciprocity of obligations. I hope you still remember. They say that in terms of this principle, party A is not entitled to claim performance of reciprocal obligation from party B, where party A has to perform his or her obligation first or simultaneously, unless A has already performed or is tendering performance of his or her obligation. This also means that the party B is entitled to withhold his or her performance until the counterparty A has performed in full or tenders fully performance. Right? And then this is, they even give an example by the lease They say that the landlord must perform first by providing the use and enjoyment of the property to the lessee. The payment of the rent is only owed at the end of month or year. Now, employment, the employee must perform first. The employer is only obliged to pay the salary or wages at the end of the period. Contractors, the building contractors must perform first. So it means that you have to have already performed. That's when you can rely on this defense when we talk about the contract. So that one we're talking about the unjustified enrichment, and then here is when we're talking about the contract. So even this one is very applicable when we look at that scenario. I hope that this makes sense. Now
So
let's go.
sorry, in the question that I asked, in the question that I asked to say, I understand. Okay, you count the 20 days. I'm now asking that if we're given, let's say, I worked at a company for 29 days and then I got another offer and I didn't show up on the that 30th day to constitute a month.
Well, they will
Will
have
it,
to pay you the days that you worked. Remember, you are paid based on the day that you worked. You have to perform, right? So without a
and
performance, you cannot
so,
just be
so,
paid.
so that's according to law. According to law, so how many days are in a month? Because in February, 29 days constitutes a month. So my
Yes, but
that's where my question is
so
sparking from, that
it's like
are
this.
considered to.
Yes, it's like this. Do you think if you get 15,000 rand monthly, do you think February you will get less? Do you think they get less or they get fully?
Get full.
Yes, they get full. They get full. So, but we'll talk about those
So if
one. Why they must get full? We'll talk
so
about those
can I
one.
can I can
Yes.
I conclude and say, if you did not work 30 days, then therefore it's not a contractual liability, but it's an unjustified enrichment.
If you didn't work, then you cannot claim for performance that you didn't work. So it means that you will not have any claim because you didn't work. But if you worked, then you can claim the money that you worked for.
Okay, so
Okay. Now let's move on. Now we go to the enrichment action by the minor, which is said that maybe it's not easy to come to exam. So let's just skip in study unit 12, study unit 11, rights of retentions and liens. We talk about the rights of retention. We dealt with some of the question about the right of retention, and I said that the right of retention, it can be on the scenario that talks mostly about, because the right of retention, it can be on the scenario that of the study unit 2, or it can be on the study unit 1. I mean, if we get a question where there's a misrepresentation and the person with the revendication is claiming back the property, now the person has to, you have a right of retention until that person paid up the full amount. Right of retention is only applicable in the lease. You when you have done those improvements, and then now the landlord has to pay for those improvements, you have a right of retention until the landlord pays. The right of retention, I'm very 100% that you know about it. We have talked about liens, enrichment lien. We have talked about this one, the necessary improvements, the useful improvements, and the luxurious. I said that the luxurious are not paid up; they pay mostly for the necessary improvements. Necessary improvements should be done by the landlord. But if you do that, you can claim it you can claim with a negotiatorium gestorum. Do you still remember that? I said that you can claim that you have done.
yes.
Yes. So yes, those one. Now this one we talk about when we talk about enrichment by means of improvements. We have improvements. We have two ways. It's when you can be bona fide occupier, you can be mala fide occupier, you can be lawful holder. It will determine by the status that you have regarding the property. And then I give example by this one. Now you still remember on the question 6 that I gave, where they said K rents a farm from L. What is this the real relationship between these two? The real relationship is that this one is lawful holder because he's renting from L, so he's a lawful holder. Now, this is very much important that you know that the person is a lawful holder when you get into examination. Now, they said that K effected the following. He built a dam, he built luxury lapa, he built sank boreholes, started, and they said that he built all these things without the L knowledge. L had no idea that this person is building. And then they said that discuss fully legal position with regard to these improvements when the lease expires. Also briefly discuss whether the position would have been different if the lease agreement between K and L had been invalid. So we are going to give two ways. Number one is that we are going to talk about the K and L real relationship, which here KL is a lawful holder. And we are also going to talk about KL now, who is unlawful holder. So who is bona fide now? Now, when we look at the lease, when the lease expires, you have to remove all the improvements. It means that K is expected to remove the dam that he has built, the luxury lapa, the borehole, and then this one he is not allowed to remove. You cannot remove the necessary improvements. This linkage, it amounts to necessary improvements. You do not remove it. You have to be compensated if the landlord, if you have improved, the landlord should improve, by the way. So if you improve that one without the landlord, then you will be paid. Now we look at the Planckatine principles, which you know from that page. We talk about those principles. You talk about all the principles that the lease may remove all structure during the lease, provided that the land is not left in worse condition than before. Once the lease expires, anything attached to the land that the lease has not removed become the property of the owner and may not thereafter be removed. This is because of accession, which you learn about in property law. The lease may claim for compensation only for improvements. Now, they said that because K did not obtain L consent, he cannot claim compensation for the dam or lapa once the lease expires. He also cannot exercise the right of retention. K's position is that he may remove the dam or lapa if it is possible. If otherwise, he won't be paid because he never seek a consent from the owner. Now, when it comes to the repair of the farmhouse, it's a necessity. But the reason why he will claim it because he did it without a KL's knowledge. So he will have to use Actio Negotorium Gestorum Contraria, or he will go to the Actio Negotorium Gestorum Utilities for general enrichment or general enrichment action. Okay, now we move on. If the lease is invalid, now he will be a bona fide occupier, and then now he will have to be compensated. You can rely on the Negotorium Gestorum Utilities so that he can be compensated those ones. So those are the things that we talk about. Well, let's move for a back. We want to wrap up this one, and then we go to CPR. And then we want to come back and explain again the Negotorium Gestorum. We have talked about this issue many times. So now you know about these two. The examination, of course, will always have a Negotorium Gestorum. But however, we have already answered the question paper, which we were talking about Negotorium Gestor. So it's going to be easier for you. And then we have those three, conditio, We have talked about this one many times, so it's going to be easier for this one. Conditio obterpem, for example, I said that is when the contract is a fraud. When there's a fraud, you know that we are talking about study unit 5. I hope that you have not forgotten about this one.
Yes, sir.
Yes, we said that a conditio in debiti on the study unit 4. As a condition in debiti, we have already even given much of the information this one. You remember that each and every question has a condition in debiti. So condition in debiti is here the way they say that Company A is under the mistaken impression that it owes 50,000 to Company B and pays this amount again, however, and then now we look at the page 31 to 41 of the study guide 1, where they talk about the requirement of condition debiti. Someone should have transferred performance. The performance must not have been due. The payment must have been made under excusable mistake, which we call estuous error doctrine. The enrichment of the defendant, the defense of loss of enrichment, and so on. So the defense of moral default and the other defense that are there. We have talked about one, the defense of change with position without fault. We talk about the one because the questions say A now wants to claim money from B, advice on the relevant action that he should use, the requirements for that action, as well as on the defenses that may be raised by B. It's very much important that you read the question and answer what they want. Most of the people in the examination, they do not read the question. Here they said, talk about the requirements of condition debiti. Also, talk about the defense that the person may raise. It's very, very much important. That's why here we have talked about the requirements, and we come to the defenses that is available to B, and we say that he can claim the defense of loss of enrichment. Those are other defenses. So now you see that it's very much important that you always focus on, or you understand what the question wants. Now, condition debiti was a really easier. General requirement for enrichment, we have many things that we talk about. At the expense, do you remember when I sent you the question paper about at the expense, and then I deal with that question about at the expense. I deal with the nature and extent for enrichment claim. Do you remember that there was a question paper that I've answered those things? I'm sure that you still, yes. So those one are things that we won't be touching them because we have already done with it. Now we look at the study unit 2 of the justified enrichment, which I said that you will be asking the examination about talking about the origin of the estoppel, which I said that they don't bring much of the scenarios. They only bring one scenario, but most of the things they just say explain. So it's going to be much easier for you. I said that misrepresentation must estoppel. You must prove that there was misrepresentation. Misrepresentation can be in the form of omission, where you have a duty to speak or duty to act, you fail to do so. We talk about this issue. I know that you still remember when we talk about the duty to speak and duty to act. And if you fail that, it amounts to omission. And then we also talk about the fault. And I said that the fault is include negligent and intent. Therefore, in the estoppel, you have to prove that there was negligent, because you can't prove that there was intent. You have to prove that there was negligent. And then negligent is that it should be a negligent on the side of the person, of the owner, that he was negligent. Now let's look at the case, one of the case about reivindication. We'll talk about the negligence, so that you're able to see in the exam. You can see here that write a critical discussion on whether fault is a requirement in South Africa law of estoppel. In your answer, you must refer to relevant case law. I gave you that is go to page 3035 and summarize that one. You will be summarizing like this. Remember, examination is a closed book, so cases must not be written in full. You must just write the way we have said, right? I hope that you still remember.
Yes, sir.
Yes. And I said that when I end, negligence continues to form the cornerstone of estoppel in South African law. You remember this question paper that I've answered and I sent to you. A takes his car to B, who sells second-hand car, to have his car valued. The car is parked on B's showroom floor where it is left for 3 days. In this period, one of the sales staff X, who believes the vehicle to be part of the stock, sold the vehicle to C for cash. A now claims the vehicle from C with ray vindication. Advise C with reference to the relevant case law. I said that you go with estoppel. Now, when we talk about this case, we check what he needs to do to be successfully. He has to claim the representation as a C, but that's not where I want. Where I want is the application. Remember, when we apply, remember what the scenario says. They said that A takes his car to B, who sells second-hand car, to have his car valued. So he parked his car on B's showroom floor, where it is left for 3 days, and then he was sold. So if we have to apply all these cases that we talk, we'll say A voluntarily left his car on B's showroom floor, a space normally used for displaying vehicles that are for sale. By doing so, A's conduct created a strong impression that B had authority to sell the car. B's employee X, acting within the apparent scope of B's business, sold the vehicle to C in good faith. The key issue is whether A was negligent in creating this impression. A reasonable person, that is how we apply the principle of negligence. A reasonable person in A's position would have foreseen the likelihood that leaving the car on a dealer's showroom floor without any indication that it was not for sale could mislead potential buyers. This is very important information that you must include when you are talking about negligent. A's reasonable person in A's position, a reasonable person in A's position would have foreseen the likelihood that leaving the car on a dealer's showroom floor without any indication that it was not for sale could mislead potential buyers. This conduct constitutes culpa as contemplated in the case, right? And I said A, through his negligent conduct, will be precluded from denying that B had authority to sell the car. In light of the principle, I said the case. And then I said that the question is whether A was negligent in creating the false impression of B's authority, given that A knowingly left his car on a car dealer's showroom floor without restricting its issue or indicating that it was not for sale. It is likely that a court will find an A negligent. Accordingly, C can successfully raise the defense of estoppel against A's vindication. A's negligence in entrusting his vehicle to B in such circumstances stops him from reclaiming it from C, who purchased the car in good faith and for value. Therefore, C should be advised that he has a strong defense of estoppel to resist A's vindication claim. That's when you are now making it conclusion so that it becomes easier. I've sent you this one, you have this document. I also dealt with you on the full estoppel and the conclusion of a contract. We talk about the conclusion of contract, and I took you back to the principle of contract. If you could remember back in the days when we talk about the conclusion in the principle of contract, or maybe I should show you.
I think it's so. Which one is? Are you opening law of contract?
Yes, this is a law of contract. I'm taking you back to the conclusion of a contract, which we have dealt with in the law of in the principle of contract. Remember, I passed that one. Let me go up a little bit. I remember. I'm reminding you about those theories. Yes, those one. Remember, the question as to when and where acceptance take effect is not unique in South Africa and has given various theories. Remember the declaration theory, expedition theory, reception theory, information theory. Remember, they said that declarations state that the contract comes into being when and where the free express acceptance. That is when she writes or signs the letter of acceptance. Now, on that question, they said that fully discuss the estoppel and the conclusion of contract. Refer to examples in your answer. So if we have to come here, we'll just come and copy this one for you to be easier for you to know the page. You'll just come and copy, then come on study guide number 2, and then you paste, which will be much easier. Then we come. According to the declaration theory, the basis of a contract consists of corresponding statement or expression of intent and not necessarily present of actually consent. For example, as they give it reliance theory. On the other side, they explain why I started on the principle of contract, so that I showed you where we are coming from, so that I showed you that some of the things that I have linkage with the contract, so that it will become much easier for you in the examination to know that there should be. Now when I talk about this one, you know about the foundation of the contract is a consensus. Remember, when we were dealing with the principle of contract, we said that the mind must meet and so on and so on. Do you still remember about the consensus?
Yes, sir.
Yes, we talk about the consensus, and we said that is this one, consensus, and we say that the parties must seriously intend to contract, and then the mind must meet, and so on and so on. And we said that if the mind are not meeting, we say that there's a dissensus rather than consensus. And when there's a dissensus, we said that someone can have a defense of Eastwar's error doctrine, whereas someone can raise the defense of a reliance, a direct reliance theory, if you could remember that one, the direct reliance theory, and someone can raise his estoppel. Those were the things that we're talking about when we're talking about the mistakes of the contract. I think that is here. Yes, it's here. It's here. You see, when there's a dissensus, someone can raise his Stuart's error, someone can go with a direct reliance theory, the way that I was explaining to you. Someone can go and then they can raise also estoppel. So those are the things that are here. The doctrine of estoppel, someone can go with it, the way I was explaining to you. So let's move on. Okay, now we have done with remember, in the examination on the estoppel, they love to bring fault. So fault is the only one that we know. This one of a prejudiced, be successful in law and so on, mostly they don't come in examination. I mean, even if they come, it will be much easier. Do you remember ultra vires acts? I said that they say intra vires and ultra vires. Do you still remember? Hello? Are you still here?
Yes, sir. I'm here.
Oh, yeah. No, I was asking about intra vires and ultra vires. I hope you are still remembering.
Sorry, sir. I can't hear you. You asking about?
I said that in the intra vires and ultra vires. I hope you are still
Oh,
remembering.
oh, yes. I was complete. I'm quiet because I'm completely lost. I forgot the way I pronounce it because I don't know the correct pronunciation. So how I pronounce it is completely different. I'm thinking, what in the world is this? I've never heard of it.
Oh, yes, ultra virus or intravirus.
Yeah, virus. That's I just say virus. Okay, it's virus, sir.
Oh, yeah. So those are
Is
ultra and
is that how you
intravirus.
pronounce?
I hope that you still remember them.
Yes, sir.
Yeah, wo.
I'm sorry.
So,
I, I But we have on both study guides because with the
Yeah, but el Travirez is on the misrepresentation because you have to perform within the scope of the company. If you don't perform that, okay. Now we are done with these two modules. I mean these two study guides. It's not gonna be a big deal as long as you follow that memorandums that I gave you. Everything will be well in the examination. So let's close
so
this chapter now and
so
let's. Hmm?
do, did you time to do the November to know the May 2024?
That question paper, only one question that I see, maybe I can say that I can do it, but let me just show you. You mean this one? Let me show you
Yes.
something. This one, this one of now question one we have already answered. I look at it and we're like, you have this one, how the course supplements the non-recognition of general enrichment in South Africa. We have already opened it, we just read it. The origin and history of estoppel. Do you remember that I showed you about origin and estoppel there at the top of the pages of the estoppel study guide number 2? From the Roman Dutch law, those legal history. It's not gonna be, something that I can say heavier for you. Now, C has sold cocaine for a price of 200,000 to D before the cocaine could be handed to D, and after D has already paid the 200,000, C was arrested by the police. The police also confiscated the cocaine. D now wants to claim the 200,000 he paid to C from C. Advise D on whether she has any possible claim against C, and if so, what the requirements for that claim are and what are chances of success. So which study guide did we talk about the contracts that are illegal?
It was study guide 1.
Yeah. If it is a study guide 1, then do you remember what we said on the contract? I said that we talk about the contract on the principle of contract. If I remember, and I said that there's a legal contract, about the illegal
Yes,
contract, and I talk about the
condition
pact delictum rule. Do you still remember?
yes,
And I said
it's
that according to
you
the contract,
unit
X2,
5,
X2P rule.
the condition up to
Yes, about the X2P rule. And I said, according to the X2P rule, all illegal contracts are invalid. And then when it comes to the claim of the money, we said that we have a defense, we have a par delictum rule. So if you are going to the exam now, we take this par delictum and then we just copy. Maybe we come on the study guide number 1 and then we paste. Then we find the par delictum
so
rule.
seeing the is that still unit 5, sir?
You mean par delictum rule, the one that I opened?
Yes.
Par delictum rule is there on the study unit 5 about those things that condition or be term, where I said that is the contract that are illegal on the study guide number 1. So it's the same. You just go to par delictum rule and we talk about the X2P on the other side. Then you apply those cases that have been given, and then you are done. How to claim? It's easier. However, if you want me to write it down, I can do for you. If you want, I have no problem with that one. But I just realized that because I've showed you about those illegal contracts, it will be easier for you to to see in the examination and to be able to answer those one. So if you will have a problem, you will let me know about the this one.
So do you mind just writing it, because
Yes,
now I'm
but remember,
looking what it's at.
remember, you remember on the study guide what I said to you. You don't write about the Roman Dutch law. No, you don't write about 5.3. You don't write about 5.2. You start to write about 5.4, the application to South African law. Don't forget this one in the examination. Never give information that is talking about not a South African law. So when you answer, you must answer based on South African law. So you will come and say an application has been modified in South Africa. An agreement may be deemed illegally in terms of the common law, where either the subject matter of the contract, its object, or its conclusion is against public policy. Contra bonimors, just like in the principle of contract, where it is neither expressly prohibited or where it is prohibited according to the necessary implication by the statute. Now, don't come here in the examination and write about Roman Dutch law and you give the requirements of the Roman Dutch law. It's very, very much important. Always look for application in South African law, then use the one. So it means that you will come and talk about the right to institute conditio, the pipe delictum rule. Then after that, you'll talk about whether they can claim and based on some cases that have been given in South Africa. I hope that you'll able to
Oh,
have that one. Yes.
all right, sir.
Yes. So when you talk about the claim, they said that application that which a party has performed. So when you get that one, you come and write on the 5.4. Any question you have about this one? This one I've already answered it about the city of Joburg. There's a
Just
question paper
trying
that I've
to.
answered. So all the questions here, I've already covered them. Yes, you can ask.
In, including the casualty, sir.
The casualty.
Yes, and also there was it's question 4 when they spoke about indirect enrichment. There's question 4 that you have on now,
Oh, you mean the case
and
of
then there was
indirect
also a question.
enrichment? No, this one of indirect enrichment, I will write it down together with a
Yes, and then there was also another.
with the causality. If you want about causality, although it's easier this one, I'll just put them down. So it's this question is question 6 and question 4 only, right?
Yes, so all the other questions, are they the same?
Yeah, this one of a taxis track to B is the same question as that one that we did. You know,
Oh yeah,
the city of council is there on the memorandum about one
and
it
the
was, yeah. So
oh
those are the
with
same
the
question.
10.
Yeah. Okay.